Hello and welcome to Holland Estates. I'm Stuart Clark.
And I'm Nick Esterbauer.
And you're listening to episode 616. Good to see you, Nick.
Nice to see you too, Stuart. It's been a while.
Yeah, no, as you know, everyone can see here, we're still working remotely here for now. My haircut is showing that. Hopefully this is the last video podcast I have to record with the shaggy do and I can get my haircut soon. But, onward and upward into a better summer and all that kind of stuff.
There's a long wait list.
Yeah, no kidding. It could be a while. Maybe there'll be another podcast still with the shaggy do. Who knows? But hello, Nick. So today we're going to be talking about an interesting decision that came out relatively recently, and the decision happens to be about a Canadian celebrity, Toller Cranston, who I am told is a figure skater. Now, Toller Cranston's a bit before my time. I looked him up. I think he was kind of in his prime in the 70s and 80s, so it was a little bit before my time. Although apparently he's fairly well known. I was prepping for this podcast just before jumping on the Zoom call with you here, Nick, and my wife was saying that she was a big Toller Cranston fan, and he has jazzy outfits. So for whatever that is worth, he is still a Canadian celebrity and well-known figure skater.
And local too, not just Canadian, but he's from Hamilton. That's one of the points I learned about him when I was looking into this.
I did not know that.
And spent the last 23 years of his life living in Mexico.
Yeah, which raises an interesting point. We'll kind of get maybe at the end if we have time to pick back up on that point there. But yeah, no, and a quite a successful, second career it seems as a visual artist as well. But unfortunately for him, he's passed away. We're talking about his estate, but for his estate as well, it's been involved in some pretty, it looks like litigious situations post-death, which have now resulted in a number of decisions coming out. Most recently, and the one we're going to talk about today, and we'll get the citation up on the post, hope you can find it easily for Canley, about there's a passing of accounts that happened in his estate. It seemed to be a very contested passing of accounts. And then recently a judge has released a cost decision on that passing accounts. And we thought it would be a good idea to kind of talk about this cost decision, and just kind of as a warning out there for any potential objectors thinking about launching high stakes litigation regarding a passing accounts, that there are some risks involved, and this case does a great job at showing that.
Sure. So just a bit of background. Toller Cranston, he died in Mexico, and he died intestate without a will. The three beneficiaries of his estate pursuant to Mexican law were his three siblings. The same would have been the case here in Ontario. And his sister ended up seeking her appointment as a state trustee in Mexico, and then ultimately applied and was granted a certificate of appointment of foreign estate trustees nominee as a state trustee without a will in Ontario. So she was authorized to administer the estate both here and in Mexico. As Stuart mentioned, Toller Cranston was an artist as well as a skater. So at the time he died, he actually had, I believe it was 20,000 pieces of artwork, most of them being located in Mexico, and in a state that was valued at roughly $6 million.
And unfortunately for Toller Cranston's estate, as we mentioned before, it wound up being, it seems, a very contentious situation between the siblings, with two siblings on the one side and then the estate trustee on the other, and a lot of allegations of including fraud and misappropriating money, and all sorts of things were raised by two of the siblings against the estate trustee. And eventually, in the passing of accounts process, these two siblings ended up raising over 300 objections in the passing accounts against the executor. As we said, there are all sorts of things from fraud to misappropriating funds to, you name it, it seems. The kitchen sink was thrown in at this, just scorched earth objections litigation process, and, all that comes with that. And in this instance, I said, we're not going to talk about the passing accounts itself, other than say, eventually the two objectors ultimately were not as successful in the passing accounts as maybe they would have wanted to have been, with the accounts having been passed. And in so doing, the judge then turned to costs and made ultimately a very significant cost award against these two objectors. And because, in part, in this instance, right at the finish line, so we're scorched earth litigation, getting to the actual hearing for the passing accounts, and they withdraw 50% of their objections at the last moment, but did not withdraw those relating to things like fraud, made the estate trustee go through the whole process of, going through all the objections, viva voce, trial evidence, maintained allegations that things were stolen. And ultimately, as I said, the accounts were passed. Now, the judge did find there were, I think, 3 or 4 instances where objections were raised that were correct, but the vast majority of objections were cleared and gotten through.
Yeah. So I found this point really interesting, Stuart, and we were just talking about it before we started recording as well, that the judge applied this percentage approach in evaluating the party's success in the litigation. So of the almost $800,000 in damages that were sought by the siblings, the beneficiaries, only $60,000 in damages were available here. And that was roughly 13% of the amount being sought. And then in terms of the number of the objections themselves, the estate trustee was successful in responding to 295 of the 300. So amounted to, I believe it was 1.5% of those objections actually being, worth pursuing to trial.
Yeah, no, exactly. And so in this instance, the estate trustee sought about $390,000 in substantial indemnity cost from the objecting parties. As Nick alluded to a moment ago, there was kind of a percentage-based approach adopted here, where they're saying, okay, yeah, you got most of your, objections clear, but there were a couple here that they were successful on, and they were kind of found to have rightly objected to things. But even then, the court says, look, estates litigation is shifted towards the standard civil rule where loser pays costs. In this instance, the objectors lost substantially. And again, go through all the approaches. Also, the judge also jumps into the fact that I have the case here, Vieterhausen, I'm sorry if I'm mispronouncing that, which is a decision relating to if you allege fraud or misconduct against an estate trustee, which is ultimately, unsupported, that also entitles the estate trustee to recover substantial or elevated costs against you. So I guess the warning there is be careful if you're alleging fraud, without actual backing to back it up. So in this instance, yes, $390,000 in costs sought. The court ultimately awards $325,000 in substantial indemnity costs against the two objectors personally. So personally have to pay this back to the estate trustee. And then also says the estate trustee is entitled to recover anything over and above the $325,000 from the estate. So the estate trustee is made whole, $325,000 from the two objectors personally, the balance from the estate. And Nick and I were talking about this before jumping on here. It's interesting here, and I'm not sure if the judge turned their attention to this. It's not mentioned in the decision that I could see. But this is an intestate scenario. 3 siblings who it appears are equally entitled to share in the estate. The balance of the cost being payable from the estate, which is basically the residue, in effect results in the two objecting parties still being responsible for an additional 2/3 of any costs over and above the 325. So they're kind of getting hit twice here, which is, once personally from their own personal bank accounts, I suppose, and once as a beneficiary of the estate. So it's going to be a big number coming out of their pocket.
Exactly. So it's pretty clear that the judge was unimpressed with the beneficiaries for pursuing this matter to trial. Their conduct in having those allegations of fraud and continuing along those lines, even though there wasn't any evidence in support of them, was seen as reprehensible conduct. And I think that was a big part of the reason for this sort of elevated cost award we saw.
Yeah, no, exactly. So, I guess a takeaway from this is if you're, an objecting party in a passing of accounts, I don't want to say be careful in your objections, but be thoughtful in your objections and don't just throw everything at the wall and seize what sticks. And if you do have objections which ultimately, appear fruitless, maybe you back off early and don't push them all the way through to trial and don't make the estate trustee run up significant costs responding to objections to only then have them abandoned at the last moment. Because if you do that, there's a good chance that if you lose, if the objections are cleared and the accounts are passed, that you're going to get a pretty significant cost award made against you at the back end. So you need to kind of compare and contrast that to what you're actually alleging. So, I don't know if this is kind of a tangent to kind of go into from this decision, but in reading through this cost decision, the judge a couple times got grumpy at the fact that the executor was required to do a full triable issues and all these objections, to produce affidavit documents, to be cross-examined for discovery, and to kind of go through all of these things for 300 plus objections, only then have some of them backed off, but had to do it for this whole objection process. And it's kind of got me thinking about the fact that we're all guilty of this to a certain extent, but applications to pass accounts were, in the rules, if you read them, are supposed to be a relatively straightforward summary process that's not like a full-blown trial. It's supposed to be an application. It's in the name, right? You have you file your accounts. There's a notice of objection that goes in. The executor then replies to the objections. Any outstanding objections with the reply goes to the judge, and they're supposed to consider them. So often these things get converted into these huge, complex pieces of litigation because parties are angry, because, who knows why. But if you're in a situation where you have someone who's raising 300 plus objections to you, and a lot of them seem meritless, maybe you push back and don't convert it to an action. Maybe you keep it in the application stream and keep it in the summary process. Because even then, I mean, under the rules, I think it's rule, I have it written down here, 74.1813.1, which allows the judge, so if it goes to a hearing as an application, and a judge hearing the application goes, you know what, I'm not ready to rule on this objection yet. I think more disclosure, whatever is required regarding this objection. The judge at the hearing has the ability to direct certain objections to separate triable issues, both under that rule, under the rules of procedure, but also under section 49.4 of the Estates Act. You can convert things to tribal issues. So you're not necessarily lost your chance to explore these in further depth if they need to be, but maybe you keep it in the more simple application system, and hopefully that dealt with more summarily, and avoid $300,000 plus in legal costs that can come from full-blown expensive litigation. But who knows, right? Some parties get angry and want their day in court, but maybe we hit the brakes a bit and think, hey, let's keep this as an application and not go down this road if it's all frivolous.
Yeah, it's an interesting point for sure, Stuart. And just looking at the quantum of damages that they were ultimately successful on, 60,000. I mean, going through this whole process is so disproportionate to that amount, and they ended up facing the consequences of dealing with this the way that they did.
No, exactly. So be forewarned, objectors. Yes, you have the right to object, but if those objections are ultimately frivolous or thrown out, and there's significant costs in the interim, they could be coming back your way. But I think that probably brings us to the end of Toller Cranston's estate. Hopefully we can forget about this more dark chapter in his estate and only think back to his figure skating days. But it's an interesting, as I said, warning to prospective objectors, and it's kind of a good summary of the whole passing account process when it does go all the way to a contentious hearing. Good to podcast with you today, Nick. And again, I'm Stuart Clark.
I'm Nick Esterbauer.
And if you have any questions, you please email info@hollandhall.com. Thank you, Nick.
Thanks.